Hi everyone, welcome back to Hands-Free Studying for the MBE, brought to you by Brainscape. These upcoming questions are related to the civil procedure topics, appeals, and preclusion. All right, let's get started.
Question 1. What is the deadline to file a notice of appeal? A notice of appeal must be filed within 30 days of the final judgment or order being appealed. However, if the United States or federal agency is a party, that deadline is extended to 60 days. And this is found in Federal Rule 4A.
Question 2. Which courts can hear appeals from the district courts? The Federal Courts of Appeal. Question 3. Define the final judgment rule. The final judgment rule states that appeals courts can only hear cases with a final judgment on the merits of the entire case. In other words, there's nothing left for the court to address. There is an exception. The appeals court can hear cases without a final judgment if there is a basis for an interlocutory appeal. Question 4. Define interlocutory orders. Orders issued during litigation that are not final. And this is from 28 U.S.C. Section 1292. Question 5. Define an interlocutory appeal. An interlocutory appeal is the appeal of an interlocutory order. Now, these are rarely granted because interlocutory orders are not final. Some interlocutory orders are appealable as a matter of right, for example, the denial of class certification, while others are only appealable pursuant to analysis under the collateral order doctrine. Question 6. What interlocutory orders are appealable as a matter of right? Injunctive orders, orders appointing or refusing to appoint a receiver, orders directing the sale or disposal of property, patent orders that are final except for accounting, and orders denying arbitration. Question 7. Can a district court order an interlocutory appeal? Yes, the judge may do so in a written order that states 1. That the order being appealed involves a controlling question of law, 2. That there is a substantial ground for difference of opinion, and 3. That the decision on appeal could help bring about the end of litigation. Question 8. The collateral order doctrine permits a party to appeal an interlocutory order if what 3 conditions are met? If the order 1. conclusively determines the disputed question, 2. resolves an important issue that is completely separate from the merits, and 3. is effectively unreviewable on appeal from a final judgment. Now note, the collateral order doctrine is extremely narrow and rare, and has only been applied to cases involving immunity and double jeopardy. Question 9. When are class certifications appealable? Class certifications are appealable within 14 days following the district court's decision to grant or deny certification. And the Court of Appeals has full discretion whether or not to grant the appeal. And this is found in Rule 23F. Question 10. What is a writ of mandamus? A writ of mandamus gives the appeals court authority to review lower court decisions for abuse of judicial authority. They can be granted if 1. The petitioner has clear and indisputable right to relief, 2. No alternative route to desired relief exists, and 3. The writ is proper under the circumstances. Remember, this is an extraordinary measure that is extremely rare. And that's the end of your 10 flashcard study round. To reach full mastery, remember to study in Brainscape. Our mobile and web app uses the latest in spaced repetition techniques, allowing you to optimize your study time and track your progress down to the finest detail. But of course, when you're driving, cooking, exercising, or otherwise unable to navigate the app, be sure to keep listening to the rest of this hands-free studying playlist. No matter what subject you're learning and what method you're studying it, Brainscape helps you rise to your challenge.